Good afternoon to you. We will now continue with the Constitution. Judiciary, that is special leave petition under Article 136 of the Constitution. In the last class, we have seen the appellate jurisdiction of the Supreme Court. That is Article 132, Article 133, Article 134 and Article 135. Now we are seeing what is popularly known as special leave petition under Article 136 of the Constitution. Please remember that Indian Constitution, in fact, Indian Constitution is unique in having such a provision. Normally, suppose let us say, I will give an example. Suppose in Indian Army, a Jawan has a grievance. He feels that justice has not been given to him on a particular issue. What he will do? He will first approach the Havildar or Subedar or captain. After rejecting, he will go to next higher up. That is rejected, again he will go to third higher up. He will not be able to go to the army chief straight away. In every department, even in government departments and even in private institution, only you have to tell your grievance to your reporting authority, who is to whom, under whom you are serving, that is your immediate superior. Then if that grievance has not been properly redressed and if you have not been given justice, then you go to the next above. If you are not able to get justice from him also, you go next above. So this is the proper channel. In English, what is called, in normal parlance, we call this as proper channel. Judiciary also like that. Judiciary also, first you go to the district court, then you go to the high court, then you go to the division bench, then you go to the Supreme Court, Supreme single judge, then division bench, like that. So this is the normal hierarchical arrangement. But here is a case where the judiciary allows any person to come to judiciary straight away. That is, Supreme Court entertains a petition straight away without making him to follow necessary procedure. This is called special leave petition. That is, it is a special leave. Leave means permission. It is a special permission to appeal. That is why we are calling this as special leave petition. Remember, under this article, the Supreme Court can grant in its discretion, underline, very important term, in its discretion, special leave to appeal. Remember, the leave is a confusing word. Wherever leave comes, you feel it is a permission. Special permission to appeal from three segments. What is that segment? From any judgment, decree, determination, sentence or order. In any case or in any matter. Number 2. Number 3. Passed by any court or tribunal within the territory of India. It is most important plenary powers of the Supreme Court. Now, the only exception to this power of the Supreme Court is with regard to any judgment of any court or tribunal constituted by any law relating to armed forces. So remember, the only exception is armed forces. All other things are allowed here. That is, in its discretion, special leave to appeal can be granted by Supreme Court in any judgment, decree, determination, sentence or order, in any case or matter, passed by any court or tribunal within the territory of India. The only exception being court martial, that is, any tribunal constituted by armed forces. This is the major point of information under Article 136. Now, the power of SLP, special leave petition, is in the nature of residuary powers exercisable outside the purview of ordinary law. This is extraordinary. This is the plenary powers. Now, remember, the appellate jurisdiction under Article 132, 133, 134 and 135 deal with ordinary appeals to the Supreme Court. In cases where the needs of justice demand interference by the highest court. If the lower court, that is high court, is not giving, did not give justice, then the highest court intervenes. However, Article 136, that is special leave petition, has vested in the Supreme Court a plenary powers or plenary jurisdiction in the matter of hearing appeal by granting special leave against any kind of judgment made by any court tribunal except military tribunal. So what I have told you is I have explained. Now let us come to the point. What are the differences between the appellate jurisdiction and the special leave petition? That we should know. Then only we will be able to appreciate the importance and relevance of Article 136. First, let us see the difference. Number one, under the appellate jurisdiction, an appeal can be entertained by the Supreme Court only against final order. Underline, under normal appellate jurisdiction, the appeal can be entertained by the Supreme Court only against the final order. But under Article 136, the word order has not been qualified by the adjective final, and therefore the court can grant a special leave to appeal even from interlocutory nature. Remember, the order need not be a final order. It can be an interim order. It can be even an adjournment. Where there is a grave injustice is noticed. Where there is a great injustice is noticed, Supreme Court can entertain. Even it need not be a final order. It can be an interim order. It can be an interlocutory nature or step in aid. Does not matter. Even if it is an interlocutory nature, the Supreme Court can entertain. This is the first difference you should remember. This is need not be against the final order. Second, under the appellate jurisdiction, the appeal lies only against the final orders of High Court. Underline, High Court. So, what is the proper channel? Below it, what is the court? High Court. So, the final orders of High Court only can be appealed against under normal appellate jurisdiction. Whereas, under Article 136 of the Constitution, Supreme Court can allow an appeal, that is special leave for appeal, from any court or tribunal. Any court or tribunal, from any subordinate court below the High Court, even without following the usual procedure of filing appeal in the High Court, or even where the law applicable to the dispute does not make any provision for such appeal. See, if the law does not provide any procedure for appeal, if the law does not provide any provision for appeal, even then the SLP can be entertained. See how vast the jurisdiction. Even if the law does not provide any provision for appeal, SLP can be entertained, and without following any procedure. You need not go to the High Court. You need not go to the next higher court. Straight away you can go to the Supreme Court. But there should be a grave mistake, miscarriage of justice in the case. If there is a great injustice rendered to the party, Supreme Court will not hesitate to interfere in the case. So, this is the second. Then, third, under the appellate jurisdiction, an appeal can lie in the Supreme Court only against judgment, degree, determination, sentence or order of any court or tribunal. Whereas, under Article 136, an appeal lies against any case or matter, not necessarily, not necessarily a judgment should have been given, not necessarily decree has been ordered, not necessarily the issue has been determined, not necessarily sentence is ordered, or not necessarily an order has been issued, not necessary. If there is a case, if there is a matter in any court, at any stage, it can be appealed against. So, these are the three important differences between the appellate jurisdiction and the special leave petition jurisdiction. Now, when dealing with Article 136, you should always remember certain points. Number one, Supreme Court has held that where an accused is acquitted by the High Court. Kindly remember, where an accused is acquitted by the High Court and no appeal against the acquittal is filed by the state, then, even then, a private party can file an appeal under Article 136 against the acquittal order of the High Court. Very interesting. You see, acquittal, a person who has been accused of a crime has been acquitted by the High Court and no appeal has been made against the acquittal by the state. So, in that case, a private party can file an appeal under Article 100. An imaginary example I will give you. A person who is accused of rape, he has been acquitted by the High Court. He has been acquitted by the High Court. And no appeal has been made by the state. As far as gender parity is concerned, all have a vested interest. So the state is not making an appeal. And the accused, so-called accused, has been acquitted. Now, the rape victim, she has a right to appeal to the Supreme Court by virtue of, High Court will not give the certificate. High Court will not give the certificate. So now, because it is an acquittal, High Court will not give the certificate. So, in this position, the rape victim can file a SLP in the Supreme Court. See, that is the another thing, one point you should remember. This decision was given in the Ramakant Rai versus Madan Rai in 2004 Supreme Court decision. Secondly, when the judgment under appeal resulted in grave miscarriage of justice by some misapprehension or by misunderstanding, then it is not only empowered but also expected to interfere to promote the cause of justice. This is Supreme Court duty. And in other words, Article 136 is the discretionary power on the part of the Supreme Court to go into the evidence in the special circumstances to ensure that no grave injustice has been done. It does not confer any right of appeal on the party. Remember, it is not under appellate jurisdiction. So, the party does not have any appeal. Secondly, the only exception is with regard to the judgment of any court constituted by the armed forces. This is the SLP. Now, we are coming to Article 138. What is Article 138? It empowers the Parliament to enlarge the powers of the Supreme Court. That is, to enlarge the powers of the Parliament can excuse me. So, extra power to the Parliament. So, Article 138 empowers the Parliament to enlarge the jurisdiction of the Supreme Court. Then comes what is very important, Article 139A. 139A, very important. It deals with transfer of cases from High Court to the Supreme Court. Transfer of cases from High Court to the Supreme Court. You remember 103rd Constitutional Amendment Act 2019 provided reservation in public employment for economically weaker section of society 10%. So this was challenged by many people. Some cases are pending in the High Court, some cases are pending in the Supreme Court. Now, the Punjab, Chandigarh, they have suggested, the Haryana, these states have suggested, the petitioners suggested, there are cases pending in the Supreme Court and there are cases pending in the High Court. So please withdraw the cases which are pending in the High Court to Supreme Court and decide yourself. This is the plea of the parties to the Supreme Court. Accordingly, it has in the recently on 24th July 2020, Supreme Court, the single judge bench of Justice Anuruddha Bose ruled to transfer the case of 10% vertical reservation for economically weaker section in public employment, which is pending before Punjab and Haryana High Court to the Supreme Court on the ground that similar petition addressing near identical issues are pending before Supreme Court for adjudication. The reservation for EWS was provided under 103rd Constitutional Amendment Act 2019. This article is very important from the point of current affairs. Now let us see what exactly the article says. The Article 139A provides where the cases involving the same or substantially same question of law are pending before the Supreme Court and one or more High Courts are pending before two or more High Courts, then the Supreme Court, if it is satisfied that such questions are of substantial question of public importance, then the Supreme Court may withdraw the case and dispose it of itself. Remember that the Supreme Court can do this either suo motu on its own motion or at the instance of the Attorney General or at the instance of the party to the case. 3. Either by the Supreme Court itself, that is suo motu, or at the instance of the Attorney General or at the instance of the party to the case. These three people can do, and Supreme Court can withdraw the case. What are the cases? Either the same case with identical case are pending in one High Court and the Supreme Court, or they are pending at the substantially same identical cases are pending in two or more High Courts. In that case, Supreme Court, having been satisfied that it involves the question of law, then in that case, the Supreme Court can withdraw such cases to itself and dispose it off. So, remember, this is Article 139A, which is important from the current affairs point of view. They may ask which state government has filed a petition on the 103rd Amendment Act and what is the decision of the Supreme Court and what are the under which article the cases have been transferred from Supreme Court to High Court to Supreme Court. Similarly, the same article empowers the Supreme Court to transfer a case from one High Court to another High Court. That is also there. Similarly, the same article empowers the Supreme Court to transfer the case from one High Court in a state to another High Court, another state. That is also possible. In addition to this, remember, the transfer of cases are permitted even under the Civil Procedure Code and Code of Criminal Procedure. So, we will end the class. We will see further provisions in the next class. Thank you. Thank you.